change that when we're in government. Thank you, Mr. Speaker.
I call Jan Logie.
Thank you, Mr. Speaker. The Green Party also categorically opposes this bill. The proposed package of reforms will be a significant change to the family justice system, the largest since the establishment of the Family Court in 1981. The reforms are stated to be driven by three concerns. One, to enable the Family Court to focus on the most serious cases. Two, that the Family Court does not have clear processes so that it's difficult to understand and navigate, apparently. And three, that the Family Court has seen its costs greatly increase in recent years despite no movement in the total number of cases accessing its services. We believe this bill is an erosion rather than an improvement of our court system. We believe that while the most vulnerable, women and children, are likely to bear the brunt of these changes, we will all pay. And on Suffrage Day, it is particularly galling to see some cornerstone legislation for the protection of women undermined in this House. This bill is what happens when the government turns its eye to how they can reduce costs rather than deliver to its citizens. This bill is what happens when government forgets that it has an important role to play in preventing social disintegration. This is what happens when the government considers short-term financial lines over long-term savings. The Family Court was established in 1980, following the report of the Royal Commission on the Courts in 1978. The Commission, through a very thorough investigation, recognised that families play a vitally important role in our society, and that a specialised forum was required to respond adequately to their needs. From this arose the Family Court as we have it now. And yet, over time, so much has been added to the court. And I think when we consider some of the administrative difficulties and the complexity of the court, considering what's been added to their role over time may help us understand that. And it stands in stark contrast to the changes that are being proposed. The Family Court has added to its jurisdiction since its establishment the care and protection of children under the Children, Young Persons and Their Family Act of 1989, powers of wardship, previously the preserve of the High Court, international child abduction law duties, the enactment of the Care of Children Act 2004, exclusive original jurisdiction under the Property Relationships Act of 1976, which was previously shared with the High Court, estates under the Law Reform Testamentary Promises Act of 1949 and the Family Protection Act of 1955, jurisdiction under health and disability legislation, such as the Mental Health, Compulsory Assessment and Treatment Act 1992, the Protection of Personal and Property Rights Act 1988, and the Intellectual Disability Compulsory Care and Rehabilitation Act of 2003, and, of course, the introduction of the Domestic Violence Act of 1995, which gave the Family Court the power to grant protection orders under this statute and represents a considerable body of work for the Family Court. So it's no wonder that we needed to update our legislation and the structure of the courts. That's not in question here. The government held a review to, I guess, considering all of that, it made sense to have a review and to consult. And the government did consult widely. And they had 209 submissions and 121 full responses were received. And the Minister in 2012 released a set of proposals for change, and these proposed changes are raised in the discussion paper. But they did not reflect, and this bill does not reflect, the feedback of the community, of those with the most experience of the family court. What that review asked for was a family court review which provided better information on how to resolve disputes, a non-adversarial, child-focused family justice system, greater transparency around court processes and accountability of court professionals, particularly lawyers, consequences for those who mislead the court or create delay, and an increase to the skill and competency of family lawyers. Now, we know what's in this bill. What it does is set up a family dispute resolution process, which is mediation and facilitation based without representation, that will be mandatory, private, non-judicial, and will be a cost to those wanting to access that mandatory service. And that is an undermining of our basic court process. That is not what was asked for by the review, and that is not what families in breakdown need. The families, as was pointed out earlier, that the philosophy that the families that should be able to work these things out themselves, those that can do. And by far the majority of families do, and they don't come near the family court. The families that come to the family court in these situations are the families in conflict who have not been able to work it out themselves. And it's absolutely essential for us as a state to be able to help those families out, unless we are to all pay for the cost of increased conflict and family breakdown. And that is what this is potentially setting up. Alongside this is, while it's purportedly about increasing the rights of the child in this process, it actually limits the role for the counsel for the child. Counsel for the child now will be appointed when there are, quote, concerns for the safety and well-being of the child, and the judge unquote, and the judge considers an appointment of the counsel necessary. This is an erosion of that service. It is a displacement of children from their centrality in this act. And we know that children are the most vulnerable when families are in breakdown. This will have long-lasting consequences. And it sets up that when part of the costs when lawyers for the child are appointed, or in other situations, that some of those costs may now be passed on to one or both parties involved in it. So here we are, saving money in the short term, considering the government's budget this year, next year, with no mind to the future cost, no mind to the harm and the pain of the families going through this process, no mind for the potential that victims of domestic violence may get caught up in the system if they're not in a place in their life to be able to disclose that they're victims of abuse. They are going to be put in situations of facilitated discussion where we have no guarantee that the facilitator has skills or knowledge around domestic violence, and the outcome of that is potentially very dangerous. This law is a travesty, and particularly, I say it again, to have this in front of the House on Women's Suffrage Day, 120 years of women's having the right to vote in this country, to see a piece of legislation that is so important to women and children's safety in front of this House undermined. It's embarrassing and sad day.
I call the Honourable Kate Wilkinson.
This bill is about modernising our family court system. It's about bringing